Okay, good afternoon and welcome everybody. Thank you for being here for today's Constitution Day event. My name is Gregory Bowman and I have the honor and the privilege of serving as the Dean of this fine College of Law at WVU, and we're very glad that you're here today. Constitution Day is observed every year on September 17th to commemorate the signing of the Constitution 232 years ago today. In 2004, our very own Senator Byrd from West Virginia in the U.S. Senate urged Congress to create Constitution Day, and a law that requires public universities to hold a Constitution Day event was then enacted. Today is a really important day in the United States of America because it recognizes the value of the American experiment in democracy and the success of a nation whose form of government began as a great experiment and is now, I believe, the oldest written constitution in the world. So we as a society, we have our disagreements, including over what the Constitution may mean, but we do so within the ambit of the rule of law, and that's very important, and it's a very powerful document, and it is properly commemorated today. And it's fitting to have a federal appellate judge here today to talk with us about how courts apply and interpret the Constitution, and I will leave the formal introduction of Judge Sutton to my colleague John Taylor, which is why he's standing up here smiling with his $1 million smile. But before he does that, I want to present the judge with two gifts. I see you only have one working arm, but we have two gifts for you. That's right, that's right. So we know that you have some connections with the Ohio State University, is that correct?
Did you hear we tried to patent the recently?
Yes. Yes, and that was shockingly struck down. I believe it was denied. So yes.
I was a little ridiculous myself.
Yes. Well, it was a valiant effort to do that. But the Ohio State University is a place from which you graduated in 1990. Is that correct? 1990, and you served as an adjunct professor there, correct? Since 1994, according to Wikipedia, which means it must be true. And I spent hours researching that. So I also note that we have someone on our faculty here at the WVU College of Law who is very familiar with both OSU and WVU. This faculty member, you may have heard of him, Dr. E. Gordon Gee, is a lawyer, and he has served on the faculty and is president at the Ohio State University and WVU. He was at the Ohio State, from 1990 to 1997 as president, and again from 2007 to 2013. And he has served as president at WVU from 1981 to 1985, and again from 2013 to today, which proves that you can come home again. I think it is fair to say that he is an expert on these two schools. So with that, we get to the present. We have two football helmets for you. Both are signed from our resident expert, Dr. Gee. This one says, the good school, all right? So that's for you. Place it on the table there.
I'm a little worried what the second one is.
Well, we'll find out. We'll find out. That's right, that's right. So that represents the excellence of OSU and its love of football and of its mascot, which is, and I quote from OSU's website, a small, shiny, dark brown nut with a light tan patch, which is incredibly exciting, I think. It's all the kind of mascot we love. On the second...
Not quite as understated as you think you are.
I'm sorry, my snark is showing. My snark is showing indeed. I'm sorry for that. The second helmet has also been autographed by Dr. Gee, and on it says, the best school. There are only two schools here, but we're still using the word best because it is the most appropriate one to represent.
The word the.
Well, it wasn't trademarked, so we can do that.
Trademark best.
That's right. That's right.
I thought you might say a best school.
A best school. That one's under review. We're still trying. So the best school to represent WVU's successes in academics, innovation, service, diversity, curiosity, respect, global engagement, and our great success in football this past weekend. So thank you. Here's your gift. Second gift.
I'll shake first, but shake that hand. Thank you very much.
You're welcome. Thank you for being here, for being such a good sport, for hearing me speak the truth about our two schools. We really do appreciate you being here for Constitution Day. And with that, Professor Taylor, you have the podium. Thank you.
Thank you, Greg. I'd just like to begin by saying that I have no responsibility for the Dean's remarks. So as the Dean explained, this Constitution Day is in a way another gift of Senator Robert Byrd, a person who was the gift to West Virginia who keeps on giving. And today, from beyond the grave, in a way, Senator Byrd brings us the Honorable Jeffrey Sutton of the U.S. Court of Appeals for the Sixth Circuit. Jeff Sutton is, by acclamation, one of the most distinguished and highly respected judges on the federal bench today, known for his sharp analysis, genial temperament, and lucid writing. You can read about some of his many accomplishments in the program, and I will not repeat those here. Instead, to provide you with some additional information, I have been researching Judge Sutton's life for tidbits that are not going to be in the program. I have used every means short of stalking him on Facebook. I have refrained from the latter because that would, of course, require me to go on Facebook, which is something practically unthinkable. Yes, and I'm guessing you probably wouldn't be on there to be found. Okay, I have learned the following tidbits that are not in your program. First of all, Judge Sutton played on the soccer team when he was an undergraduate at Williams. So had he not gone into law, we might have been treated to a sequel to Bend It Like Beckham, which would, of course, been titled Strike It Like Sutton. Okay. Between college and law school, Judge Sutton taught for a couple years and also coached soccer, right? You taught seventh grade geography and high school history, right? So I tremendously admire school teachers, and I love the idea of a federal circuit judge having spent time early in his life on the front lines of education, which I think is fabulous. After graduating from The Ohio State University, Judge Sutton was hired as a Supreme Court clerk by Justice Lewis Powell and then moved over to work for Justice Antonin Scalia. Justice Scalia, well known for hiring only law clerks from elite schools, told several reporters that he would never have hired a clerk who went to Ohio State, but he was glad that Justice Powell did because Jeff Sutton turned out to be one of the best law clerks that he ever had. So that's a great compliment, I think.
I think he meant the best law clerk you'd ever had from Ohio State.
No. I'm sure that qualifier was not part of the quote. Okay.
I know him well.
Okay, well, and I do not, so I'll defer to you on that. Okay, so Judge Sutton gained national fame by arguing and winning several big Supreme Court cases that are now regarded as part of the Rehnquist Court's Federalism revolution. Not necessarily my favorite cases, but important and extremely influential cases nonetheless. And before joining the federal bench, he had established a successful Supreme Court litigation practice from the Jones Day office in Columbus, Ohio, which I think it's fair to say is not where most Supreme Court litigators are based, in Columbus, right? So I think it's a tremendous accomplishment to have done that. And during this time, for something completely different, he also won a pro bono prisoner appeal in front of the Supreme Court in a case called Becker versus Montgomery, which you litigated against your former boss, the Ohio Attorney General, right? The judge was confirmed to the Sixth Circuit in 2003, and as they say, the rest is history. Okay. So one final word, you will by now see that the judge has an arm injury. And so first of all, I want to say I should have thought about whether he would be able to put on a coat and so forth and clear this. So he said he feels a little bit underdressed, though I'm quite confident you have faced many more intimidating audiences than a room full of well-dressed law students, right? But anyway, that's my fault, and I apologize. I also did some research into the source of the judge's injury. So I saw, he walked up and I saw the arm. And of course, my immediate thought was that he had been wrestling injustice, and no doubt injustice had a tough time, but some costs were exacted. It turns out, however, that this was a fishing injury, the judge reports. Well, I said, it looks like you had a rough time of it. His reply, of course, was, you should see the fish. Exactly, very good. Okay, so today, I love it. All right, today Judge Sutton will talk to you about one of his great passions, state constitutional law, and its contribution to the overall project of American constitutionalism. Though he rarely gets to deal with state constitutions in his day job as a federal judge, he has a long-standing scholarly interest in the field, has published a casebook, has taught that subject at Ohio State for years and years, and his scholarly interest is now culminated in this book, 51 Imperfect Solutions, States and the Making of American Constitutional Law. It's a wonderful book. I have read it. There will be copies on sale out in the bookstore afterwards, and Judge Sutton will be willing to sign a copy for you if you are so inclined. It's a really thought-provoking read, and I would recommend it to you. I'm really looking forward to hearing him talk about it today. Please join me in welcoming Jeff Sutton.
So thank you so much for those wonderful introductions. I really feel welcomed. I feel really bad about my dress. I will say, if you think I'm disrespecting you by dressing like this, then I disrespected Chief Justice Roberts last Tuesday when I interviewed him at Vanderbilt, dressed exactly in these clothes, shoes. In fact, I haven't even washed them. So everything is exactly the same. So however much disrespect is going on here, I've done it to lots of people. The Chief Justice Roberts thing was a little more worrisome because I didn't have all the narcotics out of my system yet. But happily today, you're just getting it straight, for better or worse. Just a couple things about the introductions, which I'm so glad you warned me that Senator Byrd was responsible for Constitution Day, because it allows me to modify a little bit what I was going to say, which is, first of all, they got it wrong. It should be Happy Constitution's Day. If we're going to focus on grammar, it should be plural, not singular. That's the whole point of this mission. But secondly, Constitution Day, it's so ironic that they require schools to have an event, which is to say require law schools of all places to speak, which is to say require compelled speech. See Barnett, West Virginia, not allowed. All right? Of all people to make this mistake, it would be a senator from West Virginia. Now, of course, you know, maybe it's the federal preoccupation. So I think Constitution Day, sadly, is unconstitutional. But I would be okay with Constitution's Day. I don't care how much they compelled you to do. So I'm a little bit of a inconsistent fella. The Gordon Gee thing is very fun. I love Dr. Gee. You know, when he left Ohio State the first time, I never would do this kind of thing, but I wrote him this long handwritten note about all the great things he'd done for our school. I mean, he's really a wonderful cheerleader for institutions. So lucky you, but I mean, it is West Virginia. This guy has been to a lot of places, but he only's taken 2 stops to 2 universities, West Virginia and Ohio State, so it speaks well of both of us. I actually prefer soccer, but I'm a big football fan as well. Now this, thank you, Professor Taylor, for suggesting I did this while actually trying to catch a fish, which has all kinds of assumptions. Does he catch fish? Does, you know, maybe he fishes a long time and never catches anything. The very humbling reality of this injury, and it just, age is so humbling, it's just not for sissies. I fished for 5 days in this double Black Diamond River. I could have broken so many bones, hurt myself in so many ways. Thank God I didn't. I walk off the river the last day. I'm just walking up this little blueberry patch of a hill. I'm afraid I'm going to catch my rod tip, not on a fish, on a tree. Lean backwards. I should have just let myself fall. I wouldn't have any injuries to speak of it, but instinctively whipped my arm around and basically tore it out of the socket. So utterly humbling, stupid, old man injury. But I'll take the embellishment, but I'm also going to have to correct things. Nothing inspires confidence in a speaker quite like a stopwatch. I'm going to set mine for about 30 minutes. That should leave us time for plenty of questions. I will be blown away if I do not provoke most of you with something I say today. Even when I'm not injured, I'm not a on the one hand, on the other hand type of guy. But today I am definitely just a one-hand guy, all right? So I am giving you a straight speech of exactly what I think about everything. No one else shares these views. No one. 7 billion people in the world. No one has exactly these views. But I feel very strongly they're right, and one day there'll be a second person, maybe starting today. It's very humbling to write a book about state constitutions. So before you do it, keep these 2 stories in mind. coming out of church about a year and a half ago, and a retired doctor friend of mine, Dr. Richard Briggs, stops me and says, Jeff, I hear you wrote a book. That's so exciting. Is it an autobiography? And I said, no, Dick, not exactly. And he goes, well, is it a mystery? I really love mysteries. No, Dick, it's not a mystery. And he goes, well, Jeff, what's it about? And then with way too much enthusiasm, I said, state constitutions. Well, poor Dick Briggs is a really polite fellow, and he didn't know how to respond to that. Long, awkward silence. He goes, you sure it's not a mystery? Well, if you think that's bad, it gets worse and closer to home. I'm happily married to a 7th grade English teacher. And before I sent the manuscript off to get it all published and so forth, I said, Peg, I'm sure I've got some dangling participles here and subject-verb agreement problems there. Would you mind just giving it a read and help me correct typos and what were sure to be many grammatical mistakes? And she says, yeah, sure, happy to do it. So that's a Friday. By Sunday, I notice she's like a chapter and a half in, and the first chapter is like 6 pages, so that's not really saying much. And I say, I thought this was a little more of a page-turner. She looks at me with way too much seriousness in her eyes and says, Jeff, I don't love you that much. So by all means, buy the book. Buy 2. The truth of it is, I am going to convince you to buy the book. I'm particularly interested in convincing the students that what I have to say today really could make a difference in how you practice law, and most importantly, this is a service profession after all, how you might be able to help your clients, and some really, I hope, useful ideas for how you might help your clients one day in practice. So let me go back and organize the talk along the lines of my friend Dr. Briggs and really treat this as a mystery, as I think it probably is. And I'm going to talk about 6 different mysteries in the next 25 minutes or so. So one really obvious mystery is, why would a federal judge care about state constitutions? Let me deepen the mystery. I'm in my 17th year as a federal judge. Guess how many cases I've had about state constitutions? Just one. 16 and a half years, just one case, and even that one was one from Michigan, where the Michigan Supreme Court did exactly the same thing as the U.S. Supreme Court. That was an Establishment Clause case. So my one case wasn't even an opportunity to really engage and think about this. So it should seem very strange that in a job where I do lots of writing anyway, I would choose voluntarily to write a book about something that does not implicate my work. The reality is, my service as a federal judge for the last 16 years is exactly where my convictions about this subject come from. So what do I mean by that? So my first year of law school is 1987. So in that, 32 years or so, I would describe federal law, federal constitutions, and the federal courts as engaged in this upward trajectory of recognizing more rights over time. Blue right one year, red right next year. Both sides, I would say both political parties, are very much of the mindset, if you can't beat them, join them. You get your rights, we get our rights, and if you doubt me on this, just go to the agendas, the priorities of each political party. You'll notice almost half of the priorities of each political party overlap with federal constitutional rights. And that explains why there's so much pressure on the court and these winner-take-all victories to identify, like I said, blue rights one year, red rights the next. But the constant is identifying more of them. Another way of putting that point is the U.S. Supreme Court having more control each year over the lives of ordinary Americans, whether it's one right or another right. Now, in one sense, that should not make a federal judge unhappy. In fact, it looks like my ship has come in. If you have a government job, you'd rather have a government job with more power rather than less power. If you manage money, you'd rather manage more of it rather than less of it. So I should be overjoyed with what has happened and just thrilled each day to wake up and say, what powerful things can I do today? There's just one small problem with this trajectory, one small problem with staying on this path, and that's that the American people, fools though they may be in the short term, are not fools in the long term. The American people have come to appreciate the power the federal courts, the U.S. Supreme Court in particular, are exercising over their lives in construing the U.S. Constitution, the document we celebrate today. Proof that the American people are very focused on trying to have a U.S. Supreme Court that reflects their views as opposed to their neighbors' views is our most recent presidential election. It is no exaggeration to say that an election for President of the United States turned on a sufficient number of Americans treating their vote for president as a proxy to fill one seat on a 9-member court. You can spend the rest of your life reading about 1776 and you will never find a pamphlet or speech in which anybody promoted that we break from Britain so we can create a government that puts most power in the hands of 5 of 9 life-tenured people. We have come a long way since 1776. In fact, in my talk with Chief Justice Roberts, he agreed with this very point. The footprint of the U.S. Supreme Court on American government is so far past anything the framers, who called it the least dangerous branch, would have conceived. The problem we face with the federal court occupying this power and the American people catching on with the authority that they're exercising is the great risk that we are going to politicize this crown jewel of American government. And there are two, one thing's obviously already happened and another is happening. In view of the Garland precedent, it is an absolute given that there will be a time where there is a president of one party, a senate of another party, and you will not fill a single seat as long as that's true, whether it's 4 years, 12 years, 16 years. That's a problem. You go from 9 seats to 8. 8, the court can't do anything if it's tied. That means all power is now with people like me in the lower courts. That should really scare you. It means that you may go down from 8 to 7. Okay, 7's an odd number, but do you really think a 7-member court has authority to issue a Brown versus Board of Education on Obergefell, a big, significant decision, when it's down 2 slots? They're not going to have the authority to do what we expect them to do in terms of resolving the meaning of the Constitution or state statutes. What's the other thing that is happening and is going to get worse? We judges can say all we want, that when we decide these cases, we often are unanimous without regard to which political party the judge was from, and we're not red-robed and blue-robed. We can say it, we can prove it, but if the representatives of the American people are voting in basically 100% partisan ways for U.S. Supreme Court justices and, in fact, all lower court federal judges, how can the average American not look at that and say, wait a second, this sure looks like a political body to me. Why else would the votes be 100% partisan for Gorsuch, Kavanaugh, or now all these lower court federal judges? And the same thing will flip with a new president. What's the problem with the American people thinking of the U.S. Supreme Court as a political body? At that point, they're going to ask themselves, why does this political body have authority to check other political bodies? Why can the political Supreme Court check the political president, check the political Congress, check a political governor or a political legislature? The very authority we have relied on so heavily for 230 years, usually authority exercised pretty well and pretty responsibly, is going to be something the average American doubts. And their first instinct is going to be, wait, it's just another political decision trying to check another political actor. Who says they get this right? So how do we get out of this depressing trajectory that, in my view, is utterly unsustainable and will end in tears? There has to be a détente. Détentes are very difficult to work out in international relations. They're very difficult to work out politically because most people are inclined to think they're losing more than they're getting with these kinds of compromises. They're very tricky to arrange. A détente here is even harder because no country in the history of the world has believed more in judicially enforceable rights than we Americans. It's just very much, I think it's actually a product of the Brown story, which is such a great, heroic story. But we Americans love judicially enforceable rights, and particularly judicially enforceable constitutional rights. So a group of people that likes this it's going to be very hard to wean them off of this. I think it's basically impossible to get them to focus just on statutory rights. So my solution having undersold my book, is now to oversell it. If all 325 million Americans read my book, problem solved. I'm not kidding, actually. I don't think that's going to happen, but I'm right about this. So what do I mean by that? If we love judicially enforceable rights, we have got to share responsibility for identifying what they are, identifying how best to interpret these general guarantees, and basically sharing authority with the state courts. We have 51 high courts in this country, 51 constitutions, and one of the great, kind of baffling features of American history is that we don't use these state courts and state constitutions to build law from the ground up the way we do in everything else. For some reason, when it comes to the U.S. Constitution, the U.S. Supreme Court, we race to Washington for the winner-take-all fight. So mystery number 2, how did we lose track of and forget the importance of state constitutions in American government? Here, too, I will deepen the mystery. There is not a federal constitutional guarantee that we celebrate today when it comes to individual rights that did not originate in the state constitutions. Put positively, every guarantee you care about, free speech, free exercise, equal protection, due process, originated in the original state constitutions. The greatest era of state constitution writing, forgive me, Senator Byrd, was before the summer of 1787 in Philadelphia. I'm now quoting Gordon Wood, the great American historian. It's 1775 up to and before the summer of 1787 when the great Constitution writing was done in this country. At Philadelphia, it was cut and paste. You can call it plagiarism. Don't call it original. The only original insight in Philadelphia, federalism. Splitting the atom of sovereignty, which of course the very premise of my talk today. Use these state courts and state constitutions as a way to mediate our disputes and not always winner-take-all, uniform ruling for everything in the country. So how did it happen? How did we forget these state constitutions if they were originally where all these guarantees came from? It gets worse. If you look in the 19th century, so the 1800s, and be a sad day if you had to do this, pulled out all the American common law treatises, you would have seen 4/5 of them were about state courts and state constitutions. All of the individual rights action was under the state constitutions, not the state courts. What changed everything was the Warren Court, and this is not to be critical of the Warren Court by any means. It's just a factual reality that when the U.S. Supreme Court became pretty aggressive in interpreting the U.S. Constitution, it really made it very easy to forget about the role of the state courts and state constitutions. What's happened since is what I'll call the peril of a single history. I'm kind of borrowing from Chimamanda Adichie's wonderful TED Talk, The Danger of a Single Story. It's the exact same problem. She writes about the danger of a single story. You stereotype people, you think they're just about one thing. We have stereotyped history. And our stereotypes lead to legends, myths, inaccuracies. The U.S. Supreme Court and the U.S. Constitution, the only guardian of our liberty. The U.S. Supreme Court always gets it right. State courts always get it wrong. Those are really dangerous myths. Just in the same way, it's really dangerous to stereotype somebody and think they can't do this or they can't do that. Brown versus Board of Education actually illustrates the myth. What was Brown about? Correcting the U.S. Supreme Court's tragic misstep in Plessy. The U.S. Supreme Court doesn't always get it right. How about Buck versus Bell? 8-1 decision upholding eugenics legislation? That story, one of the chapters in the book, proves the states don't always get it wrong. The eugenics story is one with just one exception. The state courts get it right in stopping involuntary sterilizations in their tracks. Just to remind you what eugenics was about, it was the idea of using science to get rid of people with mental and physical disabilities. It's about as ruthless a concept as you get. As far as I'm concerned, it ranks number 3 in worst episodes in American history. Not something you want to compete for. Slavery number 1, Jim Crow number 2. I think eugenics is number 3. The state courts got it right on eugenics. U.S. Supreme Court got it wrong. I'm not here to say the state courts are always right. I'm just here to say, guys, they're not always wrong. And if you put all your eggs in the U.S. Supreme Court basket, you will die an unhappy person. It ain't gonna work. You put too much trust in any branch of government, it will fail at some point. That is the whole reason we divided things the many ways in which we did. Mystery number 3, and this is really starting to speak now to the students. Are American basketball players smarter than American lawyers? There's no mystery to deepen here. This one is incredibly easy. Yes, yes, yes. Way smarter than American lawyers. In fact, my first piece of advice to the students is after you graduate, ideally within 3 years, take a post-grad year to play basketball. Because what you will learn in that post-grad year, ideally you know it by now, but if not, you're in law school, so you probably aren't here because of your athletic ability. So what will you learn in that post-grad year playing basketball? You'll learn that there's never been a basketball game in the history of American basketball going back to James Naismith where the referee awarded a 2-shot foul, the player missed the first shot and didn't take the second shot. It has never happened. Every state in the country, every day of the week, American lawyers are not taking the second shot. What do I mean by that? I told you we have 51 constitutions. That means in every state like West Virginia or Ohio, there are 2 constitutions that limit every state or local law, 2 constitutions that potentially limit every state or local criminal prosecution. Therefore, if you have a client troubled by one of those things, you should think about taking 2 shots rather than 1 to stop the investigation, the prosecution, the state law, whatever it might be, unless you and your client like losing. But that's an unusual thing to admit. I'm not exaggerating when I say this happens every day of the week in every state of the country. I mean, I'll illustrate it with a recent pretty famous Supreme Court decision, Utah versus Streif. Poor Edward Streif had a drug habit living in Utah. Worse for him, the day he went to feed his drug habit, he went to a drug house that some police were watching. He arrives, he leaves. That really doesn't count as probable cause. They stop him anyway. They say, "What's your name?" He gives them the name. They run it through a database, and they see he has some outstanding arrest warrants. Now they arrest him. This is not a story about a bad lawyer. This is a story about one of the best public defenders in Utah. She represents Streif. She raises just 1 shot, not 2. It's the federal Fourth Amendment shot. It doesn't look like a bad idea because she wins at the Utah Supreme Court in a 5-0 decision written by Tom Lee, I'd say a right of center justice. Because they relied on the federal Constitution, it could be reviewed at the U.S. Supreme Court. Had they relied on the state constitution, it could not have been reviewed. Edward Streif would have gotten out of jail that minute. It goes to the U.S. Supreme Court, gets reversed. Poor Edward Streif sits in a jail because his lawyers did not know what every basketball player knows. 2 shots are better than 1. I mean, if you think I'm simplifying this too much, this is just a classic move of a lawyer. Let me complicate this so much so I don't do something as obvious as try twice to win, all right? It is not hard. This ain't hard. This is about as simple as it gets. All right, mystery number 4. Okay, second shot's fine. I got it. The basketball thing worked with me. How could a state court take a second shot? What exactly do you mean by that? You said the West Virginia Constitution has a free speech clause. You said the U.S. Constitution, we know, the First Amendment has a free speech clause. Could the West Virginia Supreme Court really construe its free speech clause differently from the U.S. Supreme Court's construction of the free speech clause? Absolutely. The West Virginia Supreme Court, I'll say today for better or worse, but in the past very much for better, for the future very much for better, can do whatever it wants with state law. There's only one limitation. They couldn't construe the West Virginia Free Speech Clause, for example, to only apply to African Americans or Hispanics. That would separately violate the federal Constitution. But as to free speech, they can say as much as they want or as little as they want. And there is no limitation. You know, this might be the last noon lecture you ever attend now that I'm about to give you an assignment. But happily, it's an unenforceable assignment, and I'll be gone by tomorrow morning. No one will know, but I actually think you'll be glad you did this. If you're having trouble sleeping tonight, pull out the West Virginia Constitution. I know it's a regular sleep aid. This, by the way, is not a sleep aid. Pull out the West Virginia Constitution, go to Article 2. I think you've got the Bill of Rights now in Article 2. By the way, that's a little unusual. Most states put it in Article 1. It's the very first thing in the state constitutions. Individual rights, their Bill of Rights, Article 1. What a contrast from the U.S. Supreme Court's, the U.S. Constitution. That's an afterthought. Bill of Rights comes 1791, 2 years later. States prioritize rights. That should mean something. Just read Article 2. You will be blown away how often the language of the state constitution differs from the federal constitution. Sometimes it's word for word. I mean, your Fourth Amendment's pretty similar, but the norm is to have different language. So when you ask yourself, why could the state constitution do something different? It's incredibly basic. Different words have different meanings. Often the state guarantees are more specific. Frankly, they're often more protective. And sometimes it's not linguistic. Sometimes the language can be identical, but it still deserves a different interpretation because of the history of that state. One thing the state can do that the U.S. Supreme Court cannot is customize a right to account for a culture or history of 5 million people or 12 million people, whatever it might be, the people that live in that state. Think about free exercise of religion if you're from Utah, Pennsylvania, Maryland, Rhode Island. Those are 4 states founded by religious dissenters. Do you not think when they construe their free exercise clause, it's going to have a little more oomph than the U.S. Supreme Court construing a free exercise clause for the whole country? Or if you live in this area, Morgantown, and you instinctively hate people from Virginia, your Constitution is filled with opportunities to use that, all right? It's the whole history. I mean, I'm the bearer of bad tidings. I'm not actually sure West Virginia is constitutional. There's an 1870 U.S. Supreme Court decision which kind of gives the blessing, but I don't know. So let's leave that for another lecture. There's some other really good reasons why the state court could do something different for your client, whether a criminal case or a civil case. Simple disagreement. And there's 2 types I want to emphasize. One of them applies basically in half the cases. This is a really great opportunity. So most judges like me take methods of interpretation seriously. We have originalists, we have living constitutionalists. I'll just break them down into 2 types. There's a little more formal and there's a little less formal. I'm a more conservative, I'm on the more formal side, and I have colleagues on the less formal side, but that's basically all there is. What does that mean? Half of U.S. Supreme Court decisions are formal, half are not. If it's a formal decision and you are a more informal justice, you should start with the assumption you're going to take a different path. That's half the cases. Half of the cases, the state court judge would start with the assumption we're doing more or less, but whatever it is, we're doing something different because that was an originalist decision and I am not an originalist, or vice versa. Half the cases. Second, and this really ought to speak to the students that have had con law, or you'll remember this comment when you take con law, it's quite sad. There are quite a few doctrines in con law that basically don't hold up. In fact, the word doctrine is way more of a compliment than they deserve. I'll use just one example. In equal protection, we have something called tiers of review. This was all genius stuff from the U.S. Supreme Court. The state courts had something called class legislation, which worked just fine. By the way, this is why the state courts got eugenics right and the U.S. Supreme Court got it wrong, is tiers of review. So we started out with 2, like strict, really light, and then we went to a 3rd, intermediate. Then we had rational basis with teeth, 4. This is quite embarrassing as a federal judge. This is where I love life tenure. Professor Streif says there's now 7 tiers of review. I only knew there were 4. I mean, I'm really embarrassed about that. In fact, I'm quite confident I've been reversed on some of the last 3. That it kind of explains itself. No wonder you didn't even know there were 7. I accept Professor Streif's counting. If there are 7 tiers of review, we are 1 year from the 8th, and then we're a Wednesday for the 9th, and a Thursday for the 10th. That is not a useful, quote, doctrine. State courts should not lightly be assuming that tiers of review is a doctrine they should import into their state constitution. They should live and learn from the failed federal experience and do a better job. The last one is the The guarantees we fight the most about, the most intensely, and are the most resentful when we lose, are written in the most general language. Please, unreasonable search and seizure, cruel and unusual punishment, what process is due, equal protection, free exercise. These general terms demand disagreement, not lockstepping, whatever you say is good for our state. They demand exactly the opposite. And why wouldn't we take something as general as that and use it the way we use most federalism things, develop things from the ground up? So those are some really good examples of why the state court and your client could get a victory that they couldn't get in the U.S. Supreme Court. Mystery number 5 out of 6, if you were wondering. I'm getting there. Despite everything I just said, why is it that 95% of state court judges presume when they get a case with a state claim and a federal claim, why does the typical state court judge, forgive me, this includes West Virginia, why does the typical state court judge assume that whatever the people in Washington, D.C. at the U.S. Supreme Court said is presumptively the correct rule for West Virginia? I'm going to illustrate how crazy that is in 2 ways. Way 1, let's say tomorrow I leave the bench and I decide to run for the Ohio legislature. It could apply to West Virginia. In fact, I love mountains and fishing, as you know. So maybe it'll be West Virginia. But the point is I decide to run for the legislature in either state. I give my first campaign speech. I'm super enthusiastic and really revved up to help the people of my state. When I'm done, I get this question at the end. And they say, Jeff, you seem enthusiastic and I'm excited about your campaign. But what do you do when you get a really difficult policy problem like opioids or data privacy? How do you organize your thoughts before you decide what kind of legislation we need to fix the problem? And let's say my answer, it's not read Locke, it's not do this, it's not do that. What if my answer was this? I always ask myself just one question. What would Congress do? That's it. That was my last campaign speech. I will never raise another dime. Your political future is over in every state of the country today. Your political future is over in every state in the country, in the history of this country. It has never been okay in running for a state office to say, I start my analysis of what to do by asking, what do the people in Washington think? And that is what our state court judges do. Second example is historical. Every state, West Virginia again, is it a state? Not clear. There is a federal constitutional provision, another odd reason to be celebrating the federal constitution. I mean, Senator Byrd should have been amending the federal constitution to get rid of that thing that says you can't create a state out of a state. It's right on point. I don't know what to say. So awkward. But in the history, after the original 13 colonies, I'm generalizing, it doesn't apply exactly to West Virginia, but the essence of the point does. You had territories before you had states. So we Ohioans share something with West Virginia. We too were part of Virginia at one point. We figured a slightly different way to make self a state, which we were the Northwest Territories. So Michigan, Ohio, Illinois, Indiana, and so forth. Guess what the key feature of territory status is and the key impulse to move from being a territory to a state? While you were a territory, that meant you were controlled by the federal government. You were not independent. You weren't sovereign. That meant there were territorial governors and territorial state Supreme Courts or territorial high courts. The judges were appointed by the President of the United States. The governors were appointed by the President of the United States. They were pals of people on the East Coast and folks in Ohio and Montana and Kansas. They didn't like these carpetbaggers. And they didn't like their laws being written by people in Washington, D.C. The key impulse to move from territory status to statehood was to have your own judges, your own constitution that could be interpreted consistent with your culture, your values, your norms. And here we are saying, if I got a problem in a con law case, I ask myself, what would the U.S. Supreme Court do? Go figure. All right, last mystery. Why would this be helpful? Why will it change the world, your life, your client's life, and so on? It is so hard in American government today to find anything that unifies people, that they can all say, yeah, I agree with that. But there are a couple things. One of them is this virtue of federalism, and I'm now borrowing from Justice Brandeis. And Justice Brandeis had the wonderful insight that when we have a new policy problem, it's a good idea to let the states be laboratories of experimentation so that you can experiment on 5 million people, 13 million people. If it doesn't go well, shut the experiment down. But it's very dangerous to experiment on 325 million people at once, right? What if it's a bad idea? That has a lot worse consequences. Now, what Brandeis was referring to with his laboratories of experimentation, of course, were the key policy-making bodies in American government, legislatures. But the idea was let them trial and error. What worked, Congress can nationalize. If it didn't work, let it be. Everything I'm saying, everything in the book is just reduced to one point. How did we get so stupid not to do the exact same thing with con law? Why can't we treat our 50 state courts as laboratories of constitutional experimentation? I mean, they're debating very general guarantees about very general values. Why don't we think about this as not race to Washington, winner take all, create resentment for the losing side, but develop from the ground up through the state courts these ideas, see what works, see what doesn't work, and go from there. Another benefit of this principle, it's actually neutral. This is not something that inherently favors anybody, any political party, anything at all. In fact, maybe that's its biggest problem. It has no natural constituency except all of us if we know what's best for American government. Proof that it's neutral is the last federal judge to run around the country talking about this was Justice William Brennan on the US Supreme Court. No one doubts his credentials as a progressive. I would say arguably in the last 75 years, he's the most influential progressive justice in the US Supreme Court. He embraced everything I'm saying in this 1977 landmark law review article. On the other side, Justice Scalia, arguably the most influential conservative justice the last 75 years, in his last majority opinion, Kansas versus Carr, said everything I am saying and more. He agreed 100% with that. If Justice Brennan and Justice Scalia agree with something, that is like a biblical truth. You can take it to the bank. I mean, that is just as true as it gets. So there must be something good here. And my last point, and how I'll finish, is it's a Buck v. Bell point. If we put all our eggs in one basket when it comes to constitutional protections of liberty, property, speech, we are ultimately going to be sorely disappointed. And worst of all, we really run the risk of politicizing and destroying this crown jewel of American government. To be more concrete, every term the court has these epic cases. Sometimes they say yes, they grant the relief, but sometimes they say no. So 2 cases where they said no last term, they're very big cases. Rucho was the gerrymandering case. They put up a stop sign. They said no, not under the federal Constitution. If you want to do this, go to state court, state law. And then Bladenberg, the Maryland Cross case. Now, I'm not here to say either case is right. That is not my point. My point, though, is really simple. It's back to 2 shots. If the US Supreme Court puts up a stop sign and says, no, you cannot go here, we are not open for business on this right, you have only one option left. There's just one place to go, and that is state courts. If you want to do a constitutional ruling, obviously you can use state legislatures. And if I had been on the US Supreme Court, this is proof that I'll never be on the US Supreme Court because no one shares this view. But it is how I think about this and how I want us to start thinking about it, and I think it'll improve things. If I had been on the US Supreme Court in Rucho and that argument had been in front of me, I would have said, counsel for the plaintiffs, I get the problem. I agree this has really been hurtful to the American polity. I'm not happy with the use of computers. It's made it worse. But I have to tell you, the US Constitution does not clearly speak to this. We are very much at the outer edges of interpretation, and that gets scary, all right? If the US Constitution clearly spoke to it, it'd be a no-brainer. Of course I'd recognize the right. But in a world in which it's really unclear whether it speaks to the problem, please don't come here first. If you want to market some clever algorithm that a University of Wisconsin professor put together to show when too much gerrymandering is enough to be unconstitutional, sell it to a state court under a state constitution and show me it worked. Because otherwise we're forgetting Brandeis's advice and experimenting with a new idea on 325 million people, 51 jurisdictions at once, and that is incredibly risky. So that's what I would have said, and I think that's a very good way to think about it if the U.S. Constitution doesn't clearly speak to it. All right, so I am so thrilled to be here. I'm going to take at least one of these helmets home, and but I'm really honored to be your Constitution's Day speaker, at least as long as it's a constitutional holiday. And I would love to be challenged by anything and everything, whether about football, basketball, soccer, fishing, or state constitutions. So thank you very much.
Hearing this makes me really envious of all the people who've gotten to be in your classes at Ohio State. I'm thinking of enrolling and coming in. I really enjoyed the talk. One of the things that I love about the book, right, is as the judge was saying at the end, right, most people, most of the time, federalism is just a shield you carry around with you to get to your preferred policy result, right? And one of the things about the judge's book is he is a true believer in federalism as a structural principle, right? It can go in one direction or another, but structurally, this is a great idea. It's
like the greatest principle in the Constitution, democracy.
Yeah, right.
Doesn't always go the way you want. It's neutral.
And so to take somebody else, so Heather Gerken at Yale.
She's for it too.
Federalism is for everyone,
yeah.
right? So anyway,
I agree.
Love to ask some questions.
Yes.
Hi, Judge Sutton. Thank you so much for your remarks. I found them very intriguing. You mentioned in your talk a lot about Brown versus Board of Education. And given what you were saying, it seemed like, even though you only have one hand right now, that there were arguments that you could present on both sides. And so I was wondering, if you were on the Warren Court in 1954, when Brown was decided, which way would you have come out?
Yeah, no, that's easy. I think the great mistake was Plessy and its equal protection. I mean, I think that you don't even need to know the history. You don't even need to know the context. The language carries the day. But on Brown, I love this topic because it illustrates some things that are really important to this conversation and trying to get us away from this danger of the single story. So speaking of unusual bedfellows, there's a justice on the California Supreme Court, Goodwin, we're very good friends, but he would be perceived as a more liberal judge, I as a more conservative judge, and he wrote a law review article in the Yale Law Journal this March, and you really ought to check it out, because what does Goodwin do? Goodwin embraces the 51 Constitution's point, and he takes on the hardest story on this issue, the Brown story. Guess what? It's incredibly complicated how this worked. I'll give you just two of them, and then you can go read his review and then my response to the review. One that just blew me away, 28 states, through legislation or courts, rejected Plessy by 1910. There were probably only 40 states. By 1910, there's about 40 states. 28 of the 40 rejected the separate but equal doctrine. Very sad reality of separate but equal in Plessy. It came from a state court judge in Massachusetts. Lemuel Shaw, one of the great state court judges in history, he had a bad day. Judges have bad days, there's no doubt about it. So it's so complicated. So if you'd been a judge back then in Plessy, and you listened to what I just said about Rucho, you would have looked at all the state courts had done and said, no, separate but equal is not consistent with our tradition. Look at these 28 courts. And state constitutions, state legislatures, we want to figure out what the norms are in this country, we look there. Brown itself is funny because we think of Brown as federal courts right, state courts wrong. There are 5 cases in Brown. 4 of them are about the state issue. Of those 4, 3 comes from federal courts of appeals like mine, and 1 comes from the Delaware Supreme Court. Of those 4 state cases, guess which got affirmed and which got reversed? All 3 federal cases got reversed. The only affirmed case was the state court decision. The Delaware Supreme Court was affirmed in Brown. Guess what the 5th case involved and decided that day? Bowling versus Sharp. At issue in Bowling versus Sharp was the continued segregation of the District of Columbia public schools. Guess which state controls the District of Columbia? No state controls the District of Columbia. It is controlled by Congress. In other words, it is a federal territory. That wasn't a state problem. So up to 1954, the United States Congress was embracing segregation. So this is why the danger of a single story is the key takeaway. It's not that one is good or bad. It's the risk of simplifying, reducing history, and therefore creating myths, legends that aren't true, and in my view, today, are leading people like Edward Streif to be in jail. You know, I used to blame law schools for this problem. I actually decided it's people like me, former 7th grade teachers. The danger of the single story grows out of 7th grade civics. And I understand that. I was teaching 13-year-old boys. Do you really think I was going to tell them about 50 state constitutions? I mean, the idea of just describing the judicial branch was hard enough. Counter-majoritarian, checks and balances, C. Brown versus Board of Education, ends Jim Crow, U.S. Constitution good. You know, that was it. That's all you could do. I mean, they're 13 years old. But there's no explanation in high school and in college and in law school. We have to end the danger of a single story. It's as bad for judging people as it is for judging history. Other questions? Yes?
Bryce Schumann, third-year law student. Thank you for coming.
Yeah, thanks for coming to listen.
It's very compelling. As far as the exponential growth in federally recognized rights that have really gone on over the past century or more, it seems like there's a common misconception that the 10th Amendment is almost toothless. What are your views on the possibility of introducing that in the world of litigation?
Yeah, so the 10th Amendment is very much a part of what is going around in the states. I'm going to guess the Attorney General of West Virginia, that's a priority for, I think it's him, and I know it is in Ohio. I'm, you know, as a guy who thinks states are worth paying attention to, I like reading the 10th Amendment. But the reason I like reading the 10th Amendment is it just reminds you of something that the whole Constitution tells you, which is the creation of this national government doesn't mean the removal of all these existing powers in the states. Now, whether the 10th Amendment does much work in cases has never been obvious to me. I mean, to me, I've always thought the question is, you know, it's usually a Commerce Clause question. Does Congress have this power under the Commerce Clause? Does it have this power under Section 5 of the 14th Amendment? Does it have, you know, the taxing and spending power? There is no spending clause, by the way, but there is the authority to raise money and then, of course, to spend it. So I've always been a little suspicious of the actual work the 10th Amendment language does, but I very much appreciate the fact that it reminds us that we still have a dual sovereign system. The national government is one of enumerated, not unlimited powers. That to me is quite useful as an educational device. You know, but let me kind of answer this, look at this from a slightly different way, and I know this isn't exactly the question you asked, but it really gets at what I consider a real problem in politics and American government, and I'll pick on Ohioans to make the point. So I have Ohio neighbors that care deeply about some issues. I don't have to say whether it's a red issue, a blue issue, it just doesn't matter to me. They care deeply about it. I love that. I think that's very American. They wake up in the morning, and instead of focusing on what they can do to fix that issue in Ohio, they wake up in the morning and start thinking about how they can make the people of Arkansas, West Virginia, California, and Wyoming subscribe to their view as to what the right way to deal with that issue is. Now, if you wake up in my community in Bexley and you want to tell the people of Arkansas, West Virginia, California, and Wyoming what to do, you're not going to do yourself any good by going to the Ohio governor, the Ohio Supreme Court, the Ohio legislature, because their sovereignty ends at the border. So if you have that attitude, you have to go to D.C. That means you go to Congress, and above all, recently, you go to the U.S. Supreme Court. The worst part with my neighbor having this attitude is he or she is then successful. It works. They get the U.S. Supreme Court ruling that makes the people of Arkansas, Wyoming, West Virginia, and California do something my neighbor friend cares deeply about. He or she's really happy. Then the people of Arkansas, West Virginia, Wyoming, California, not fools, say, I got that playbook. And they do the same thing. They return the favor. And they now tell the people of Ohio how to do something on this right or that right. And then my friend is deeply resentful. Like, I hate those people from West Virginia and Arkansas and Wyoming and California. Who do they think they are telling us in Ohio how to handle this deeply complicated issue? That is the typical American. Now, part of me loves this because I think it makes me proud to be an American. We always think we're going to win, and we don't think we're just going to win locally. We think we're going to crush the whole side nationally. It's probably why we win World War I, World War II. But the thing you have to remember about this little thing is you're going against other Americans. And they're not fools, and they're going to flex their muscles as much as you flex yours. So why can't my neighbor friend in Ohio wake up, care deeply about this issue, and just say, I'm going to fix it in our town of Bexley, the city of Columbus, the state of Ohio, and when they're done, have the courage of their convictions that the people of West Virginia, Pennsylvania, Wyoming can follow it if it's a good idea. Where did we get into this coercing our neighbors in other states and telling them how they had to do things? Why not set a good example? And if it's good, they're not idiots. They'll adopt it. So, that to me is the 10th Amendment. Focus on solve problems at home. And once you've solved them, have the courage of your convictions that people will see the insight and either modify it or adopt wholesale what you did. But this winner take all leads to so much resentment, and then an effort, of course, to control the U.S. Supreme Court, which means the politicization of the Supreme Court, which means the destruction of the U.S. Supreme Court. Yes?
I just wanted to thank you again for...
Are you a student, a professor?
Yes,
A 3? Okay, great.
Yes.
So you guys get these clients, you're going to take 2 shots, right? You got to take 2 shots. You never get in trouble for failing the extra shot. There's no downside. All right, go ahead.
So thank you again for taking the time to come down to visit us on Constitution Day or Constitution's Day. But my question was concerning the kind of underlying theory of the laboratory of democracies. I tend to be more of a flexible kind of constitutional when I look and examine those issues. Again, not a scholar, so. But I would say that it's my impression that when it works well, and it's great. But unfortunately, there are times where it doesn't. And I think that the market failures that happen in the democratic process are real, and a lot of us are seeing those today. Gridlock, undue influence of special interests, big money in politics, things like that. So my question is there ever a time when the federal judiciary should step in when there is a market failure? Particularly if, let's say, for example, a state decides to strictly and overtly deny fundamental rights to individuals, and those fundamental rights cause serious harm.
Yeah.
So I think that for in instances where those people are affected, going through the typical machinations of the political process might not be possible. They may be disenfranchised, or they may have their safety at risk.
Yeah, so this is a great point. It's a really great question. I now think you are a lawyer, not a 3L. But let's just kind of review the bidding and put the question in context. So one simple point is, if the U.S. Supreme Court says no, you may not like the decision, but if they say no, unless you just really like being unhappy, you got to take the second shot, right? Okay, so they said no in Rucho, and for now you can't take the gerrymandering claims to federal court and the federal Constitution. And the states are the only avenue. So I'm pretty confident we're on the same page there. In other words, regardless of whether the U.S. Supreme Court's right, it sometimes says no, and when it says no, you really have to use the state court. So I think that one's pretty easy. I'd be surprised if anyone disagrees with me about that. So now we get to what are more complicated questions. And another way of putting your point, and I think this makes the question harder, and it's probably what a lot of people are thinking about, is we still have a federal constitution. It still has these guarantees: equal protection, due process, free speech. And if you're a citizen of the United States, you are entitled to have uniform protection in every state in the country against discrimination based on race or anything else that implicates these guarantees. And it's very strange to think of a world, a country, in which those really important guarantees are enforced in patchwork fashion. I think this is one of the things you're getting at, where, if you're in Arkansas, it means one thing with this right, but if you're in Ohio, it means something else, because the U.S. Supreme Court hasn't done it. So this is kind of the uniformity point. So what's easy, I'll answer another easy question first, then the harder question. What's easy is when the U.S. Constitution clearly speaks to it, of course. I'm not for delay. I'm not for waiting for state courts. My paying attention to the state courts only applies in the really hard questions, all right? Now, we might have trouble agreeing on what the really hard questions are, but we all would agree there are some questions that are harder than others. And for me, the real value of what I'm saying applies to the hard questions. And since I haven't been controversial enough, let me double down and go really controversial to illustrate two paths as a way of thinking about this. So let's talk about same-sex marriage and abortion, okay? You're going to love me for this. So whatever you can say about those two rights in the constitutions, it's hard to say, given the development of the rights, that the constitutions, when they were written, clearly spoke to that. I mean, because it took an awful long time to identify them. So to me, those two rights are rights that are ones that aren't self-evidently explained by the text of the Constitution or its history. So it means the court is in this harder area of interpretation. And let's examine the path of Roe and Obergefell as two different ways to deal with this. Roe, I'm now channeling Justice Ginsburg, no opponent of Roe, said the great mistake of Roe was deciding it too quickly. Honoring the winner-take-all, we're open for business, we'll take this very difficult debate and say one side wins it all, the other side, you can't vote on it. And her point is if they'd waited longer, more state legislatures would have protected the right, state courts using state constitutions could have protected the right, and that if, which is what Justice Ginsburg would have wanted, they had eventually constitutionalized the right to choice, it would have been something that would have led to a lot less resentment because it would have affected fewer people in fewer states, because it would have given time for more states to fix the problem from her perspective in that way. Here we are, America circa 2019, still dealing with Roe. Let's compare that to Obergefell. Obergefell, interestingly, starts that story almost the same time. A year before Roe, 1973 and 1972, the U.S. Supreme Court gets a case called Baker from the Minnesota Supreme Court, asking to identify a 14th Amendment right to same-sex marriage. Not a single justice in the U.S. Supreme Court in 1972 was willing to do that. They put up a stop sign. With a stop sign, there was only one place to go, state courts and state legislatures, and it's a very long story. It's 1972 to 2015. It involves Hawaii, 2 steps forward, 1 step back. It involves a Vermont constitutional decision about a unique provision, common benefits clause in the Vermont Constitution, and then it involves the epic 2003 Goodrich decision by Chief Justice Margaret Marshall. One of the things that drives me to drink, when you hear that, boy, Judge Sutton became an alcoholic, it's just so sad. He had so much promise. It'll be this fact, that in 50 years, we are going to be celebrating Obergefell and Justice Kennedy's opinion, which was not a profiling courage. That was the popular thing to do in 2015. You want to profile and courage, that's 2003 Goodrich in Massachusetts 4-3 decision that the legislature almost overruled. That is the path-breaking decision in this area. But single story, we don't talk about state courts and state constitutions. It's not even a footnote anymore. So 03 leads to other steps forward, steps back, Iowa, Minnesota, quite a few states. 2013, the U.S. Supreme Court can nationalize. Let's wait a little longer. And it's 2015. You find me one member of the U.S. Supreme Court willing to reconsider Obergefell. I haven't talked to any of them, but I don't think there's a single one. I don't know anyone willing to do that. They stabilize the right by the path of creating the right and using state legislatures, state courts, state constitutional amendments. Which would you rather have? No, I'm not going to leave unanswered the really hard question. 1972 to 2015, there are a lot of gay couples that wanted to marry that were not able to marry. I get it. I get that point. But, con law is really complicated. Look the other side of it. Look what's happened in Roe. They protected a lot of things, but it's a very unstable right. So you really don't focus just on the scene. You got to see the seen, the unseen, the short term, and the long term. And if you think of the long term and stability of law, you're going to agree with me. Using state courts and state constitutions is a help. It ain't going to hurt us. It's a help.
We have time for one more if it's quick.
The problem is usually me, not the questioner.
You were saying that territories don't have constitutions written by them, but by the federal government. So in Puerto Rico, I heard they had I guess it's 2 questions. First off, I heard they had 3 governors or so in a week, and I guess that's due because they weren't issued by Puerto Ricans, but by feds. And also, how come most of Puerto Rico does not want to become a state? Because if they were a state, they would be able to make their own constitution and stuff.
Well, they have to get the approval of Congress, number one. It's not just up to them, but
Well,
I
I
think
mean,
you're
I
right
thought-
that they're ambivalent.
I thought they, because don't they get like a vote every year to if they want to become a state or not?
I've often wondered why more law professors don't teach state con law, and this question is exactly the answer. You're expected to be able to answer any question about any state or territory. They're like, wow. I don't know the answer. I really don't know Puerto Rico. It isn't a state. It's not it is a territory like Kansas used to be a territory, but it's actually a unique territory. It has quite a few different features than other territories, but yeah, I mean, we know with Puerto Rico, they not only have bad weather, they have bankruptcy problems, and that's a really serious question as to what's going to happen. But they need Congress's permission, and they need to have support in Puerto Rico, and I don't think it's a majority support yet. One more time?
The last time they conducted a referendum, statehood did not win.
Yeah.
It was one of three positions, independent statehood or continued status. And continued status won by a little bit.
Yeah.
All right, so with that, we're going to, there's a table set up out in the lobby where you can get a copy of the book if you like, and Judge Sutton will be so gracious as to sign your copy. And then Sean, is there food somewhere?
There should be pizza.
Oh, there should be pizza
Ah,
outside as well,
eat.
and you have an opportunity to do it. Thank
Thank you, John. I really appreciate it.
That was so good.
Oh, you're kind.
So
You're
wonderful.
kind. I
I
really
really thought that was good.
Oh, it's really fun. It's really fun. I was trying to speak.